want to welcome you to this important webinar and congratulate you on taking the step to educate yourself and how to preserve and protect your legacy for your loved ones for life. First, just a little background about our firm. Our firm is located in the heart of Old Town Orange on Glasell Street. CKLH was founded over 30 years ago, right here in the city of Orange. We like to say that our clients get big firm experience with small firm service. This means that our principal attorneys have over a combined 25 years in the practice of law and have handled hundreds of legal matters to completion. But when you call our office, we know you, our staff knows you by name, and you will not be passed off on to an associate with less experience. And it is almost always possible to get your attorney on the phone that same day. We work as a team so that we can provide our clients with exceptional legal representation. My name is Julie Lopiccolo. I'm one of the principal attorneys in the firm, and I've been practicing law for 11 years and a partner in this firm for 8. And over the past 8 years, my practice areas have also included family law and trust litigation. And family law is where we find families in crisis, and trust litigation is when failed estate plans lead families to crisis. I'm a mom of 2 beautiful kiddos. I also co-founded and run a local nonprofit dedicated to injury prevention in young children. And despite, or maybe because of my litigation background, I'm passionate about estate planning. I am uniquely situated to serve clients as estate planning counsel because I know how to keep your family out of conflict and out of court and make sure that your family and your legacy is protected if the unthinkable happens and when the inevitable happens. So what is estate planning? Let's look briefly at what estate planning is exactly. So typically it refers to these legal documents created to manage your affairs if you become incapacitated or when you die. But what is life and legacy planning? So I'm not a really big fan of the term estate planning or the regular process of it, because the traditional form focus only on the legal documents, leaving out a whole part of what it actually takes for those documents to work, and leads to big messes, failed plans, and loved ones who are lost, confused, and in grief when something happens. They don't know where to turn, who to talk to, where to find your assets, and you may have left behind documents, but they don't know what to do with those documents. So what we do here is called life and legacy planning. And while it certainly does include wills and trusts and healthcare directives, it's more than that. It's a proactive plan that we support you to create that leaves your loved ones with legal and financial clarity, support to make wise decisions, a trusted advisor in our firm, and the documents and guidance necessary so if you become incapacitated or when you die, your loved ones know what to do, what you have, how to find what you have, and who to turn to. On top of that, when done well, life and legacy planning supports you to have more financial and legal clarity during your lifetime, which results in you living your best life and creating a legacy worth leaving. So who do you do it for? As I mentioned earlier, estate planning or life and legacy planning is something you do for yourself and your loved ones. And it's not just for you if you have a lot of money in the bank. But the real reason I imagine you're here is because you really care about the people in your life. So let's take a moment right now and make some notes. Imagine the people you are doing this for. Who will come forward to handle things for you when something happens? Not necessarily who you would want, but who would it be on a practical level based on where you live, who lives near you, and who would be the first on the scene? Make a note of who that person might be. If you are married, perhaps it would be your spouse. But what happens if something happens to you both together? Who would step forward next? Now, is that the person you would want? If it is, great. Now we need to think about if they know how to find what you have, who to turn to, and what to do. So make a note, I need a plan for the people I love. And do you have a business? If so, would the people counting on you know what to do and how to keep the business going without you? If not, note that down too. What about your pets? Do you have 4-legged loved ones who would need care in the event you were not available? If you would like to leave some instruction for them, make a note for yourself on that. So the first thing we can see about life and legacy planning is that someone will have to make sure your affairs are handled after you die. And by making those decisions and plans now, you are relieving a huge burden for them and saving them a potentially expensive, lengthy mess to deal with. So life and legacy planning is first and foremost the roadmap for the people you love once you're gone. But life and legacy planning is not just for them, it's for you too. What we hear repeatedly from our clients is that the process for life and legacy planning brings clarity and relief around legal and financial decisions. That leads them to feeling responsible, making better decisions as a parent, making better decisions as a member of the community, and making better decisions when it comes to your relationship with your spouse, money, or work. And yes, that means having a plan for you if you become incapacitated and can't care for yourself. So make a note now of who you would want to care for you if you couldn't care for yourself. Would they know what they want, how to make decisions for you, find your assets, pay your rent or mortgage, know how to communicate with your doctors? I know it can seem unlikely to happen, but if it does, the consequences are significant and can lead to you not being cared for in the way that you would want. We see it all too often. Someone becomes incapacitated or dies, and their friends or family call us. They're lost, confused, grieving, and by then it's too late for us to truly help them without a major investment of time and money. So before we move on, let's look at the plan that's already in place for you, the estates plan. And what would happen if your friends and family called us if you did not do any estate planning in advance? So some of you may already have created a set of documents with an online service or a law firm, or you may have no documents. So if that's the case, the state of California will have to make the decision for you. And there is a plan in place when you become incapacitated or when you die. It may just not be what you want. So let's take a look at the state's plan for you. Once incapacitated or deceased, the court determines asset distribution through conservatorship or probate. This process incurs significant costs, including attorney and executor fees, appraiser fees, court filing fees, bond premiums, and creditors' claims. For instance, in a recent probate of approximately $1 million, attorney's fees amounted to nearly $23,000. And that doesn't include the filing fees, which are around $1,500 to start. These costs are preventable with a basic trust plan. And probates range from 18 to 36 months. And during that time means your family does not have access to your assets. Finally, probate is public, so anyone can go down and see what your family is getting. A will. A will is a public document after your death, and it does not avoid probate. When a will enters probate, it puts creditors on notice that your loved ones will be receiving money. And the only plan that is private, avoids probate, ensures your children receives your assets when you want, is a properly funded trust. And we'll talk more about that shortly. Can you imagine your 18 or 20-year-old child receiving hundreds of thousands of dollars right at 18 years old? I've heard many stories about children who have received maybe just $150,000 when they turned 18. They didn't finish their college education, and they never really learned how to support themselves financially. So as one piece, you may want to ensure that your kids receive their inheritance protected from lawsuits against them, future creditors, or even a future divorce. We see many of our divorce clients that did not segregate their inheritance, so they may lose all or a part of it in a divorce. For example, a client of ours got married and her dad died. He left her a small inheritance of $50,000. And because it came outright to her outside of a trust, and she didn't know how to keep it separate, as most people don't, when she got divorced, her husband got half of its value. If her dad had left her that money in a protected trust, it could have easily been traced. She could have used it to invest in a business or real estate, and she would have kept all of it when she got divorced, because it would have been clear that it was separate property without the need for a prenup. So before we move on from talking about your kids, if you do have minor children at home, I want to tell you a quick story that can illustrate where your children are at risk, even if you have already named guardians in a will. If you've not named guardians at all, and about 70% of parents haven't, so you're not alone. But if something happens to you, the choice about who raises your kids will be left to a judge to decide who doesn't know you and doesn't know your family. Several years ago, the Barber family, 2 parents and 3 sons, went on vacation in Arizona. They were from California. While they were there, they were in a car accident, and both parents sadly died. The boys lived, and when the authorities found a family member to pick them up, they found one of the aunts who happened to be estranged from the kid's mom. And that aunt decided she should be the one to get custody of the kids and control of all the Barber's money. And she used that control to prevent the children from seeing any of the other family members. But luckily for the Barber children, another aunt came forward who knew what their parents would have wanted and filed a challenge to the first sister taking custody. After more than $100,000 of court costs and nearly 2 years of litigation and a huge family fight, a judge did decide that the other aunt should raise the boys. But he appointed a financial conservator of the boys' inheritance, left behind, to the tune of $100 an hour. And the boys will receive whatever is left right at the age of 18. So our office will help guide you through this process and select guardians for your children and their inheritance so that the Barber story does not become your story. So let's talk for a moment about healthcare directives and if they'll work when you need it. We've talked a little bit about what will happen to your children if you don't have planning in place. But what about what happens to you if you become incapacitated and you do not have a healthcare directive in place? This is what happened to Terry Schiavo. Many of us remember the Terry Schiavo case that involved a legal battle over the life support of Miss Schiavo, a 26-year-old female who was in a persistent vegetative state. The case centered on her husband's desire to remove life support while her parents opposed it. The husband and the parents fought for years in court in this case. Ultimately, the husband won and she passed away. But these terrible events could have been avoided if Terry had properly executed an advance healthcare directive that expressed her end-of-life wishes and identified the person to ensure those wishes were carried out. So let's talk for a moment about planning techniques that don't work. How assigning beneficiaries can fall short in securing your assets for your heirs. Many people think they can avoid these conflicts by either owning property jointly, designating a beneficiary for their assets, or designating a will. Joint ownership has many problems. If you remember, when you were in escrow on your home, you might remember that the escrow agent asked how you wanted to take title to your home. If you were single, you've probably just said in your own name. If married, you might have said joint tenants. And if you did take property as joint tenants, you would have the benefit of avoiding probate upon the death of the first of you to die. But the downside is you can ensure that the surviving joint tenant won't give all the property away to a future spouse or lose all the assets to creditors. A consideration that people with blended families and maybe people with businesses must think about and must make. Additionally, you lose the benefit of what is called a step-up in basis after one spouse dies. In California, if you took title as community property, you get the benefit of reassessing capital gain when one of the joint tenants dies. But if it's outside the trust, half of the property could still be subject to probate. So designating a beneficiary is an option where assets permit it, such as life insurance. But many assets don't permit beneficiary designations. And where you designate a beneficiary, the beneficiary will have unlimited control over the assets. And worst of all, naming a minor as a beneficiary ensures that your insurance or retirement account will have to end up in court if you die before your kids are 18. And as we already talked about, signing a will won't work either. You need a trust. The only way to keep your family out of court, either in the event of your death or incapacity, is to have a fully funded living trust. This means that you have a trust prepared that is properly custom drafted for your family to say exactly what you want to happen to your assets in the event of your incapacity or death. And all of your assets are owned in the name of the trust. If you already have a trust, chances are it's not been updated since you created it, and it's likely out of date because your life has changed, the law has changed, and your assets have changed. It's also very likely that your assets are not even properly owned in the name of your trust. One of our clients in the past had a $3,000 estate plan done before she came to us. That didn't work when the family needed it because it wasn't updated and the assets were not owned correctly. And this is all too common with form documents or with law firms who don't properly guide you to make informed, empowered decisions, and then keep your plan updated and assets owned properly. If you have an existing trust, please note that you need your trust reviewed and your assets looked at to make sure that they are titled correctly. Lifetime Asset Protection Trust. When you create a trust, you have the power to decide how your assets will be distributed to your heirs. Unlike a simple transfer at 18, the distribution follows the schedule of your choice. Most commonly, our clients opt for a revocable living trust, distributing assets to their children at specific ages or stages, such as 1/3 at 25, 1/2 at 30, and the remaining balance at 35. Another option is 1/2 upon college graduation and the balance upon completing graduate school or some other event that you choose. There's also the approach that provides even more protection than you can do simultaneously with your estate plan that some of our clients like to choose. Creating an irrevocable living trust is nearly untouchable by creditors, exempt from estate taxes, and secure in the event of a divorce. These are some of the techniques we can use to ensure your children have the best chance at life if you were to die while they were young or still minors, or even in certain cases for your adult children. This is all part of the discussion we will have with you in detail at your planning session. So what about estate taxes? Currently, this won't apply to many of you, but just in case any of you do have individual assets in excess of $13.61 million, jointly with a spouse would be $27.22, or are expecting an inheritance that can put you in that category. You need to know that your family can lose nearly half of your assets in excess of that, even if you receive it by inheritance to the government. So if this is your situation, make a note to discuss it with me at your planning session. One important thing that I want to mention to all of you here that does apply is that there is currently $11.9 billion in California Department of Unclaimed Property. And most of that got there because someone died and their family overlooked an insurance policy, bank account, investment, or retirement account. If nobody claims it, it goes back to the state. And this could easily happen if you do not get financially organized and make sure your family knows what you have in the event of your death or incapacity. Think about it for a minute and consider that if you didn't make it home tonight, who would know how to find what you have, where it is, and how to access it? What would be lost forever because no one even knew it existed? If you aren't clear on this, please make a note that you need an asset inventory. The last thing I want to ask you is this. If you had to choose between the people you love receiving your money or your values, insights, stories, and experience, what would you choose? Most people say that if they had to choose, they would choose their non-monetary assets, their intellectual, spiritual, and human capital. So it makes no sense that most estate plans completely ignore this altogether. I keep a voicemail of my father on my phone because I know that I will miss his voice when he is gone. So what we offer is a legacy interview where we record a beautiful message for your family. We guide you through to make sure your family has more than just a voicemail. So now you know what doesn't work. Doing nothing, having a will only, or even getting an estate plan created by a lawyer who just focuses on documents, doesn't ensure the protection of your kids or your assets, doesn't ensure your assets are owned in the right way, and who will take care of things when something happens to you, doesn't keep your assets out of court or out of the Department of Unclaimed Property, and could very likely leave your family unnecessarily at risk of a big mess in the event of your incapacity. And here's the other thing. What you need is different than what any other family needs because your family dynamics are unique to you. Your assets are unique to you. And the law as it applies to your family dynamics and your assets are specific to your circumstance. That is why we begin all of our planning with a 2-hour working session called a life and legacy planning session. It is a process our clients love, and you will too, because you'll feel so good about all your choices after it. Really understand your options and actually get your planning done the right way. And know that you have a plan that works at the right price for you and your family. Our process begins with the inventory of your assets, which you need no matter what, to ensure that when something happens to you, your family knows what there is, where it is, how to find it. Otherwise, your assets are at risk of being lost, or your family is left with a confusing mess. So, we'll support you to create an inventory of your assets, and then we'll have a 2-hour working meeting where you will make informed, empowered decisions for the people you love. So, you know what you need to have a working plan in place. During that meeting, we'll get to know your family dynamics, your assets, and you'll get to learn enough of the law to choose the right plan for your family at the right budget. And what is absolutely unique to our firm, because of our background and knowledge of trust and family litigation, we understand how and why things fall apart for families. And we will help you identify those potential areas of conflict and will plan to best avoid them so your family never ends up in court or broken by conflict. So you're likely wondering what all this costs. Our average fees for planning run between $4,000 and $8,000, depending on your family dynamics and your assets. But what's most important is that you will understand and help to choose your fee during the life and legacy planning. And by the end of our time together, you'll know with certainty that you are making the best decision throughout your life, and your family will know how much you cared about them and loved them in the event of your incapacity or death. We will guide you through everything. So what's next? A consultation. Call CKLH today and complete your consultation. Don't forget to mention you watched this webinar to get your consultation fee with me waived. Number 2, you're going to schedule your life and legacy planning session with our client services director right after your consultation. And then you're going to complete your homework and become more financially organized than you've ever been. And every dollar of the $750 planning session goes directly to your estate plan. And because you watched this webinar, we'll have that consult with you for free to answer any questions you have before you sign up. And remember, before you even come in for your session, we're going to help you get organized. You will have all the tools needed to communicate your wishes to your family. Ultimately, this is something you do for the people you love, and we've designed the entire process to be as easy as possible for you and to support you to do the right thing. Thank you all for attending the CKLH Estate Planning webinar. Our Client Services Director is available for all your questions, so give us a call anytime. Bye-bye.